Welcome back again to Bankruptcy with Ben. And in a prior video, we were discussing the case of Ali Chowdhury, a real estate businessman who had been thrown in jail by a federal bankruptcy judge for not cooperating with discovery. To recap, Mr. Chowdhury was directed by a bankruptcy judge to turn over various information in the context of a bankruptcy proceeding. He did not turn it over, and the judge said, okay, well, you're going to go to jail until you turn it over. And now we have another case, which again explores the intersection of bankruptcy and potentially financial crimes. And this individual has not yet been sent to jail, but the way it's looking, it seems as if that is not a far-off possibility in the near future. So let's have a look at this article. Okay. And this is from the Tampa Bay Times. A businessman out of Clearwater, Florida, is accused of taking $100 million, which is an enormous sum of money. For the first time since being accused of taking $100 million from medical trust funds, Clearwater businessperson Leo Gevoni faced questions in a courtroom Friday morning as bankruptcy officers sought to expand the search for the missing money. So what does this all mean? There was a fund that was set up to cover other people's medical bills. And this individual, Mr. Gevoni, was administering this fund and supposed to take this money, use it to pay medical expenses. And now the accusation is that he did not actually pay it, but instead stole the money. So we know the money is missing. The money did not go to pay what it was supposed to go to. And we suspect, or the bankruptcy court suspects, that this individual, Leo Gevoni, stole the money and used it for himself. Gevoni took the witness stand as bankruptcy attorneys quizzed him about his ownership of more than 24 companies for which they found paperwork at his offices. The court previously banned him from this building. He could not go into his office, and granted bankruptcy officers control of the premises and several of his companies. That is pretty damning. He ran a company, and now he can no longer access his own company. So let's take a quick look at what this company was here. We have, again, Tampa Bay Times. There was a company called Big Storm Brewing. It was owned by this man, Leo Gevoni, and it was in bankruptcy, and the bankruptcy court said you have to give control of the company to a bankruptcy trustee. Federal bankruptcy judge Roberta Colton on Wednesday issued an order that will give the Rising Group Consulting, so another company that's appointed by the bankruptcy court, now they step in and they're taking control of the company. So Leo Gevoni owned it. He may still own it, technically, but he can no longer control it. It comes as Gevoni, a financial advisor, faces investigations by the FBI, the SEC, and the IRS for bankrupting a St. Petersburg nonprofit by orchestrating a $100 million loan to his own company. So there was a nonprofit that he was supposed to be running, and then he had his own company, this other company, and he lent $100 million from one company to another company. Not good. He had a fiduciary responsibility to administer funds for the benefit of other people. And what did he do? He took that money and lent it to a company that he controlled. The money was never repaid. It was siphoned from more than 1,500 medical trust funds, which were set up to pay medical bills for the injured and disabled. So not only that, people were injured and disabled, desperately needed the money, and he took it. So pretty egregious. Recently filed court records also show that 1 year after the missing money came to light, Gevoni or his associates were still in control of a small number of trust funds and money set aside for Medicare payments. So not good. He's still controlling this money, even though he improperly lent money to his own company, and it seems as if he probably stole it. The trusts have been transferred to companies Gevoni owned that bankruptcy attorneys believe to be defunct. So he just took the money, put it into shell companies, and then seemingly just raided those companies. It turns out they've been operating surreptitiously all along. Bankruptcy trustee Michael Goldberg wrote in a motion asking the court to sever Gevoni's control of the companies. The bankruptcy trustee is saying they were operating, and they were operating in order to, it seems, just benefit Gevoni. And therefore he cannot control those companies anymore. The court agreed and appointed a restructuring officer. And he has not yet been charged with a crime, denied any wrongdoing, blah, 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 blah. Okay. So, one second. Court injunctions issued in January and February allowed Big Storm Brewing to pay workers through the end of January, but then said you can no longer spend any money. However, the taproom remained open. Not good. The trustee filed a motion saying to the judge, hey, this business is continuing to spend and has not been providing financial records. The brewery is considered an asset of Gevoni's that could be transferred to the bankruptcy estate. So the one question which isn't so clear to me from these articles is, how does this all come about? There's a whole financial investigation, and I wasn't clear where did this all come from? What was the impetus of it? So I was trying to understand, how did this all unravel? That was the missing piece to this puzzle, is the articles were not explaining who was in bankruptcy. Was it Leo Gevoni? Was it this brewing company? Was it some other third party? How did they end up in bankruptcy? What was the connection to Leo Gevoni? It's still a little bit muddled, but what it seems like what happened is there was a nonprofit that this Mr. Gevoni founded called the Center for Special Needs Trust Administration. And he founded that company in 2009. He subsequently resigned from the board. He resigned from the board in 2009. And then in 2024, 15 years later, they discovered enormous financial mismanagement, which is what led to this investigation that he stole $100 million. So, two things that stuck out at me. First of all, I'm trying to think how to phrase it, but first of all, if you're screwing around, you're going to get caught. It may not happen right away, but eventually the numbers are not going to add up. And when people are losing money, when it's discovered that money is missing, people are going to start to ask questions. And even if 15 years he was doing it and didn't get caught for 15 years, it eventually caught up with him, and now he's most likely going to end up in jail. Again, we'll see what happens, how it all plays out, but the way it looks right now, it's certainly not looking good for him. The second interesting thing is that in criminal law, it's up to a prosecutor to make a prosecutorial ruling. In criminal law, a prosecutor makes a decision whether or not to prosecute. So if, for example, you discover some kind of financial wrongdoing, a bankruptcy can be a very effective civil tool where a court in a civil context will have wide-ranging powers to investigate everything. And anybody who's ever touched any money with the company will have to answer questions from the bankruptcy court. So you, as either a creditor of a business or a individual with a fiduciary role in a business or an executive in trying to uncover something, sometimes bankruptcy can actually help to clean things up and find out where all the missing money went. So it's a very powerful tool, and unfortunately, if you're committing financial wrongdoing, you need to be exceedingly careful. So if you're the one that perhaps you didn't keep your financials as pristine as they should have been, even if you lacked malintent, you file for bankruptcy, you can open up a whole can of worms. Courts can really start investigating and digging into every transaction in a way even more so than the IRS might. So think of it as inviting an audit from the government. So, if you're filing for taxes, you might get audited, you might not get audited. If you file for bankruptcy, you're saying, here, feds, come and investigate me, look at everything. So you really need to make sure, if you're the one that wants to file and you need this kind of protection from creditors, this bankruptcy relief, make sure that your financial records are in very good condition. That's why it's super, super important to speak with an experienced bankruptcy counsel, experienced financial professional, an accountant. Make sure everything is in order. Sometimes, unfortunately, if you did not conduct your business in a way that in a way that would look good to the outside world or to a court, and if you're concerned about that, bankruptcy in some instances might not be the best option. Some instances it can be very good, but you really, really need to be careful to balance that and see, make sure that you're not inviting scrutiny that would put you in a worse position than you would have been otherwise. So just to wrap up with one final point with this, back to our friend Mr. Gevoni. So it gets really bad for him. It says on 5 occasions, Gevoni either declined to answer on the advice of his counsel or pleaded the Fifth Amendment, a protection against giving self-incriminating evidence, which, again, always applies. You can always plead the Fifth. That included questions about how he funded his ownership of some companies and whether he had their tax records. Now, you can plead the Fifth, but it's not going to look good for you in a civil context if you're pleading the Fifth. So in a civil context, a court can hold that against you, so to speak, for pleading the Fifth. They can make an implication that you're hiding something by pleading the Fifth in the civil context. In a criminal context, they're not allowed to. So it's a big difference between civil and criminal. You may still want to plead the Fifth because you'd rather have that civil penalty than the criminal penalty, but just be aware it's not really a get-out-of-jail-free card. A federal bankruptcy court found him liable already for the missing trust fund money and $20 million in interest. The money was taken from a St. Petersburg nonprofit that Gevoni founded to manage trusts that Gevoni founded to manage trusts set up to help the disabled and injured. Middle District of Florida Judge Roberta Colton indicated she'll grant bankruptcy officers control over all but 2 of the companies identified from Gevoni's office records. And she wraps up, I'm not prepared to hold you in contempt just yet, but I expect cooperation. So, not a good look for Mr. Gevoni. Not a good look at all. Again, you need to be exceedingly careful if you file for bankruptcy. It's a very, very intense scrutiny. If you're a creditor, it can be often very good for you if a bankruptcy is filed. I've seen many, many times in my creditor representation practice where bankruptcies have been filed, and as a creditor, we've been able to use the tools of bankruptcy court to really leverage and put a lot of pressure on bankrupt individuals and bankrupt companies, and often work out better results for my client than they would have been had the bankruptcy not been filed, and really was a poor decision in many cases by the company to file for bankruptcy. So that's the lesson for today. Bankruptcy, usually only civil, criminal can come up, so something to be aware of. If there's any other interesting updates with this case, we'll keep you posted. But for now, that's it, and we'll see you all on our next episode.